So, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. I'm as a group representative. We will presenting a case regarding of trespass to land that involves the two parties, which is Villa Putra Management Corp and Malay View Sendirian Berhad. So, this case involves two parties, which is the plaintiff and the defendant. The plaintiff will be on the side of Villa Putra Management Corp, while the defendant will be on the side of Malay View Sendirian Berhad. So, especially this case is about the trespass to land and how it was started. Let's look at the material facts. So, on January 2010, the defendant, the plaintiff, was informed that a trespass occurred made by the defendant while they are conducting Regalia project. This is because they are a property developer. So, after this thing was discovered by the plaintiff, three things discovered by the plaintiff made by the defendant, which is the laying of the termite on the plaintiff's existing land, the construction of the drainage system, as well as the underground structure. And then the plaintiff has taken an action and made a claim to the defendant, but the defendant just admit 2 out of 3 offences made by them, which is the construction of the drainage system as well as the underground structure. The market rent was used as the reference by the plaintiff to claim damages for loss of use of the trespass area and had a claim on exemplary damage upon the defendant's profit. So market rent can be referred as a composition that was made based on the rental value of a property, while the exemplary damages is the composition made because of the defendant's wrongful act, which is the trespass. So, claim of the defendant said that if it was liable, there should be until 12 November 2011. Then, no further damages can be awarded except for the nominal damages, as there is no proof of the defendant acts. So, defendant said they just can be compensated only for the nominal damages as long as there has no proof to their action. But in here, they are clashed at the same time. The defendant was filed a lawsuit against the architect because it is the one of the reason why the trespass is occurred when the OOI, an architect of for the Regalia project, was charged because of their sketch has a flaws that suddenly make it the defendant make a trespass on the plaintiff's land. So, two legal issue would arise in here, which is we can see for the first legal issue whether the defendant's liability was proved by admission of fact of enroachment in pleadings when it sued the architect in separate action for making defective drawings on project. And the second one is whether the defendant was bound by previous admission and could not contended otherwise in instant action by the plaintiff.
Next, for the legal principle, first we have the law of trespass. Trespass to land consists of any unjustifiable intrusion by one person upon land in the possession of another. Second, we have evidential value of admission. Admission made in pleadings are admissible against the person making them, and a person cannot resile from admission of fact made by him in his pleading. And for the third one, we have user principle. A plaintiff can claim for either loss of use of his land or the profit the defendant has made by using his land. Moving on to the counsel argument. I'm as a plaintiff, Villa Putra Management Corporation,
and I as defendant, Maryland View Sendirian Berhad.
So what I want to argue here is in January 2020, the defendant had encroached into my land when the defendant poured the tarmac on my land road. Not only that, the defendant also built underground structures on that land, which are the underground telecommunication manhole, electric cables, and liquefied petroleum gas.
Why the defendant denied the acts of trespass complained by the plaintiff?
I, as the plaintiff, request for exemplary damage.
Why the defendant took the stand that only nominal damage should be awarded as regard to other structures that were claimed to have been constructed in plaintiff land, as there is no proof the value of the trespass portion of the land had diminished.
I argued that the trespass had occurred since 2006.
While the defendant dispute plaintiff's claim that the trespass is still continuing by contending the trespass had ceased on or before 12 November 2011 by relying on the photograph enclosed to the second survey report prepared by Piles.
I claim that the market rent started from the trespass until all the structures were removed. Besides, I also requested exemplary damages.
While the defendant argues that the damage payable should only be for market rent for use of the tar road until 12 November 2011, when the plaintiff erected a chain link fence and prevented further use of the road by the defendant.
Next, let's move to the ratio decidendi. Okay, so what is the rationale of the decision from the issue, right? Okay, first, for the evidential value of admission principle, the judge had taken a quote from a case known as YK Fung Securities Sdn Bhd against James Chapel Far East Limited on the year of 1997, where the judge in this case stated that once the party to litigation has admitted a fact in his pleading, he shall not be heard to contend the contrary in the trial or in any appeal therefrom. Next, for the law of trespass, the defendant had encroached into the plaintiff's land by laying out tarmac and building underground structure by following the original structure plans as prepared by the architect. For this issue, it was graphically illustrated as far back as in the year of 1874 in a case where the judge stated that if the defendant placed a part of his foot on the plaintiff's land unlawfully, in law it is considered a tort. And also, in tort law, specifically in trespass, no damage is required as trespass is actionable per se. And last but not least, the defendant argued that by laying out the tarmac on the plaintiff's road, it is considered as betterment to the plaintiff's land, where this fact should be taken into consideration to make a decision. So, in addressing this issue, the judge take into consideration of a statement made by a judge in the case of Cheng Hang Guan and others against Perumahan Farling Penang, Sdn Bhd and others in the year of 1993, whereby the judge stated that proprietary estoppel is one of the exceptions to the general rule that a person who spends money on improving of another has no right to claim reimbursement or any proprietary interest in the property. So that's all for the ratio decidendi. Moving on to the decision and remedy, the judge therefore rewarded the plaintiff damages as for the loss due to the trespass by the defendant from the period of January 2010 till December of 2012 at RM1.10 per square feet. This ended up with a summary of RM312,222.24. Next, as for the drainage and the underground structure, the judge gave the defendants a period of 12 months to remove it as plaintiff by the defendant. And at the same time, the defendant is required to pay the plaintiff the market rent at RM1.10 until the structure is removed. And last but not least, the defendant has to pay the plaintiff an amount of RM100,000 in total.